Judgment in the appeals matter, Strip Canal Company and United Utilities.
Lord Sumption will explain the judgment of the court.
This appeal illustrates the unintended and unthought-out side effects of complex legislation. It arises out of a dispute between a sewerage undertaker and two private canal companies. The question at issue is whether a sewerage undertaker has a statutory right to discharge treated effluent and surface water into private watercourses such as the Respondents' canals. It is common ground, and perhaps obvious, that without a statutory right, they must either obtain the canal owner's permission or acquire a right of discharge by compulsory purchase. They would naturally prefer not to have to do either of these things. Both procedures are time-consuming and may be expensive. For many years, water and sewerage services in this country were provided by public authorities under statutory powers conferred by a succession of enactments. Before 1973, the statutory sewerage undertakers were almost invariably local authorities. Thereafter, they were regional water boards. In 1989, the industry was privatised by the Water Act 1989, which created a new statutory framework, with some points in common with the previous statutory regime, but also some significant differences. The Water Act 1989 was replaced 2 years later by the Water Industry Act 1991, which consolidated it with a number of other enactments relating to water and sewerage services. Before privatisation, statutory water undertakers had had an implied statutory right to discharge treated effluent and surface water into private watercourses such as canals. This was the result of the decision of the Court of Appeal in 1897 in a case called Durrant and Branksome Urban District Council, which interpreted the Act then in force as having that effect. The main features of that Act, which gave rise to the implied right to discharge into private watercourses, survived into successive later Acts of Parliament until 1991. The Water Industry Act 1991 removed the provisions on which the implied right of discharge had previously been based and replaced it by new provisions in different terms and which operated in a different way. The canal companies argue that the changes deprived the sewerage undertakers of the right of discharge into their canals which had previously existed. The sewerage companies say that the right continued to be implied into the new Act. This argument is based on a comparison between the complex provisions of the 1991 legislation and its much simpler predecessors. They say that the effect is the same. The Supreme Court unanimously rejects that contention for reasons given in a judgment which I have prepared. In summary, the features of the old legislation which give rise to an implied right of discharge have been significantly modified and new features have been introduced. The new statutory scheme is no longer consistent with the old implied right of discharge. There is, in principle, no reason why commercial companies who have acquired sewerage franchises should not have to pay for the use that they make of other people's watercourses. There is, however, a more limited alternative argument advanced by the sewerage undertakers, which is more promising. This relates to the outfalls from sewers which were already in existence and already discharging into private watercourses when the 1991 Act came into force. The Supreme Court unanimously holds that the implied right of discharge from these existing sewerage outfalls continued after the passage and the coming into force of the 1991 Act, notwithstanding the disappearance or alteration of the provisions on which that right had previously been based. There are two reasons which are set out in my judgment and in those of Lord Newburgh and Lord Toulson. The first reason is that a sewerage undertaker has a statutory obligation to allow the owners or occupiers of adjacent property to connect to its sewers. It is also forbidden by statute to discontinue the use of an existing sewer without providing an equally effective alternative sewer to serve the same properties. These provisions have existed for many years and were continued in the 1991 Act. Their effect is that when the implied right of discharge into private watercourses came to an end on the 1st of December 1991, the date that the 1991 Act came into force, the sewerage undertakers could not simply stop discharging from existing sewers through existing outfalls into the respondents' canals. It would have been physically impossible to stop up the exits without allowing the effluent and surface water to back up through the system, and it would have been contrary to the statutory provision preventing them from discontinuing the use of an existing sewer without supplying an alternative. New rights of discharge could therefore have been acquired by compulsory acquired by compulsory purchase, but not straight away. It must therefore have been Parliament's intention that existing statutory rights of discharge should continue. The second reason is that a right arising under an Act of Parliament is not, as a general rule, abrogated by the repeal of that Act, unless the later repealing legislation or some other legislation shows an intention that it should be abrogated. Far from showing any such intention, the Act of 1991, for reasons already summarised in the context of the first reason, must have intended that a right of discharge which has already arisen upon the construction of a sewer and outfall under pre-1991 Acts should continue into the new statutory regime. The Court of Appeal treated all rights of discharge into private watercourses as coming to an end upon the coming into force of the 1991 Act. The Supreme Court allows the appeal of the sewerage undertakers, but only in relation to sewerage outfalls already in existence when the 1991 Act came into force.